The prosecution case was that the parcels constituted public land belonging to or reserved for Kenya Railways Corporation, and that the accused persons, acting in concert and in abuse of their respective offices, facilitated compensation to private persons and entities in respect of that land. The accused persons denied the charges. The court had the prosecution case over a long period of time, and subsequently the defense case. The record also contains technical survey documents, planning records, committee meetings, minutes, valuation reports, payment records, and map overlays, all of which the court has carefully considered. The judgment proceeds on the evidence on record, the exhibits produced, the applicable law, and the settled principle that the burden of proof in criminal proceedings rests throughout on the prosecution. The charges, and I'll go by accused persons. The first accused person, Professor Mohammed Swazuri, was charged as follows. Count 1, conspiracy to commit an offense of corruption, contrary to Section 47A(3), as read with Section 48 of ASECA, particulars being that between 1st of July 1999 and 30th June 2018 within Nairobi City County, jointly with others not before the court, he conspired to fraudulently cause payment of Kenya shillings 221,375,000 to Kbukwo Investment Limited as compensation for LR numbers 9084 to 9088, alleged to be public land. He is also charged with abuse of office, contrary to Section 46 as read with Section 48 of ASECA, the particulars being that on diverse dates between October 2016 and February 2017 at the National Land Commission offices, being the chairperson, he improperly used his office to confer a benefit by facilitating compensation to private entities for land alleged to be public land. He also faces an alternative charge of breach of trust, contrary to Section 127(1 as read with Section 127(2) of the Penal Code. The particulars are that, being a public officer, he breached the trust placed in him by facilitating payment of public funds for compensation of land alleged to be public land. The second accused person, Salome Ludenyi Munubi, similarly faces the charge of conspiracy to commit an offense of corruption, the particulars being same as I have stated on count 1 above. On count 3, she is charged with abuse of office, the particulars being that on diverse dates within the same period, being a public officer at the National Land Commission, she improperly used her office to confer a benefit by facilitating compensation for the said parcels. In the alternative, she is charged with breach of trust, the particulars being that the second accused, being a public officer, she breached the trust placed in her by facilitating payment of public funds for compensation of the said parcels. The third accused person, Tom Aziz Chavangi, is also charged with conspiracy, and the particulars are the same as I have stated in count 1. He is also charged with abuse of office, the particulars being that on diverse dates, being the Chief Executive Officer of the National Land Commission, he improperly used his office to facilitate payment of compensation for land alleged to be public land. In the alternative, he is charged with breach of trust, the particulars being that the third accused, being a public officer, he breached trust by facilitating the said payments. The fourth accused person, Francis Karemi Mogo, is also charged jointly with the others in count 1 for conspiracy to commit an offense, and the particulars are the same as stated. He is also charged with abuse of office, particulars being that on diverse dates, being a director of finance and administration at the National Land Commission, he improperly used his office to authorize or facilitate payment of compensation for the said parcels. In the alternative, he is charged with breach of trust, particulars being that he breached trust by facilitating payment of public funds for the said parcels. So, and in this regard, the principles drawn from Fairview Estate Limited versus Anne Wangare Kirima and two others, and the case of Cosmas Eni Katungo versus Njue Kiari and others, are persuasive. Until authenticated, survey plans are withdrawn or cancelled through lawful procedures. Those dealing with land are entitled to act on them. I therefore find that although titles existed, the prosecution did not prove that they had been lawfully impeached. On the fourth issue, whether if none of those matters was proved, criminal liability can safely be imposed on public officers and private entities who acted on the footing that titles existed. In my judgment, it cannot. Criminal liability, particularly under SECA and the Penal Code and the Penal Code invoked here, requires proof not only of the external act complained of, but also of the illegality of the act and the culpable state of mind accompanying it. If the prosecution failed to prove that the land was public land, failed to prove that it was unavailable for allocation, and failed to prove lawful impeachment of the titles, then the basis upon which public officers and private parties interacted with the land remained the existence of titles and official records recognizing those titles. As regards the public officers, the prosecution evidence itself showed a segmented institutional process. PW22 proved the movement of funds through the NLC account, but this evidence was not confined to the financial trail and did not establish illegality of payment. PW24 synthesized the prosecution case, but its conclusions on ownership were not supported by primary documents of title or vesting. And even the proceedings records show that some of the bank-related documentary processes attracted legitimate objections as to disclosure and warrants. On the defense side, the third accused case was that he merely implemented committee decisions within the commission structure, and that he neither participated in titling or land acquisition. The fourth accused case was that he only came in at the final stage of disbursement and acted on duly evaluated the entire evidence on record. I find that the prosecution failed to prove its case against the accused persons beyond reasonable doubt. The evidence raised suspicion. It disclosed administrative conflict and procedural uncertainty. It did not prove beyond reasonable doubt that the suit parcels were public land, that the compensation was unlawful, or that the accused persons possessed the criminal intent required by the offenses charged. Accordingly, pursuant to Section 215 of the Criminal Procedure Code, each of the accused persons is hereby found not guilty and is acquitted on all the counts facing him, her, or it. And that is all.
This has indeed been a long-awaited day by all the accused persons. This is a matter that has taken more than 7 years, and they've been waiting patiently for the day, and we believe and justice has been served in the words that you have used in the judgment. And it's a good day for them. You can see their faces. And we do thank you immensely, because you took over this case at a stage when it has so much progressed before your brother. And at that point, we had almost become, it was not a very good situation, but you have rendered justice nonetheless. We do thank you immensely, and we wish you the very best in your journey at the top. We'll be meeting there. That's why we practice consistently. We do.